What a difference a judge makes. In this video, we're going to look at a couple of judges, one in the Karen Reid trial and one in the Sarah Boone trial. And stick around to the end because I'm going to show you a clip of what happens when a judge isn't so professional, what the media thinks, and how that can affect their career as a judge. We're going to start with a judge from the Karen Reid case, and then we're going to go to the judge in the Sarah Boone case. Let's watch their demeanors. They both have to deal with a conflict that the defense attorneys brought up, and see if you can see the differences in their demeanor and bias. So let's have a watch.
I just saw the verdict forms, and as we discussed yesterday, the amendments that the court indicated it would make on the verdict.
Oh, no. Okay, I did not say I'd make it. I said I'd think about it. I said I was tired and I needed to think about it.
What you said before you were tired and you needed to think about it was you agree that there needs to be not guilty options for the subordinate charges under count 2.
I said that it made sense to me, but no, I did not change it upon looking at it because the verdict slip, this verdict slip as submitted to the jury, is exactly how it always is in Massachusetts.
Can I ask you a question then? I don't really care how it always is in Massachusetts. I care about whether or not it's appropriate.
It's appropriate.
Two different things.
It's appropriate.
Let me make my argument, if you wouldn't mind, Judge, why it's not appropriate. For a superior charge, they have to decide that she is not guilty of the superior charge, and that is the starting point of whether or not she is guilty or not guilty of any subordinate charge, often called a lesser included. Once they decide that she's not guilty of the superior charge, now there's two additional charges that they've been instructed they must decide whether she's guilty or not guilty of. How do they decide that she's not guilty of the first subordinate charge, involuntary manslaughter?
Okay. Anything else you want to say, Mr. Jackson?
I'd like an answer from the court. How do they decide that she's not guilty of involuntary manslaughter on that verdict form?
That's their decision to make.
And how do they make it if they don't have an option to check a box that says not guilty?
They don't check the box that says guilty, do they? And then when they go to the next block, they don't check the block that says guilty, and on the top, you're left with not guilty. Okay?
So it's the absence of the check mark that the court determines is the not guilty finding by the jury.
Yes, that's what the verdict slip reads. It reads not guilty. If they don't check block 2, 3, or 4, the verdict slip reads not guilty. Okay? That's how it is, Mr. Jackson.
Well, and apparently that's how it's going to be because of the court's order. That is not how it should be, and it's over our strong objection. They need to see that there is a not guilty option for the subordinate charges. If they come back guilty on, for instance, involuntary manslaughter, that's immediately appealable. They didn't have an option on the verdict form to find her not guilty. It's almost like the court is directing a verdict of the subordinate charges.
Okay. I disagree with you. Mr. Yannetti, you've seen verdict slips exactly like this. Okay?
I actually haven't really.
Have you had no lesser includeds?
No, we've always had lesser includeds, but I have not seen a verdict slip there where not guilty is not an option for the lesser includeds.
Okay. I disagree with you. All right.
Not guilty. That is what the defense attorney is asking for. They want an option that says guilty and not guilty for the lesser included charges. The judge is trying to say they only have guilty and then the lesser included charges have ticks on them. So you don't have a not guilty. Can you see his argument that by not having a not guilty, it infers that they have to kind of tick some of the boxes? I hope you can get that. I thought it was amazing that they had this argument. On the screen is the video that I did regarding the verdict forms and the outcome. And the judge didn't ask a question. That was vitally important. What do you think? Was she still smarting over not getting her way regarding the jury forms? That's something to ponder. That was the judge in the Karen Reid case. And what did you think about her asking the other defense attorney if he's ever seen a verdict form with lesser includeds where they had a not guilty box? Okay, now let's watch the next judge in the Sarah Boone case.
I did not believe the reasonable doubt instruction was complete just from memory, and I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please? Well, here's the first problem. That's the wrong instruction. Florida Supreme Court revised 3.7 earlier this year. That is not the appropriate definition of reasonable doubt. It is not what was read to the jury during jury selection. 3.7 now reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. A reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Judge, I'll have it redone in arguments.
As long as we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
And this is an excerpt from when
Give me a moment. That seems to be the standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening remarks. 6 through 10 are optional. We haven't decided which out of the optional instructions 6 through 10 we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law. You know, that in many ways we do it where we give them the law at the very end, you know, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
So what do you think? Are they night and day? Wait. I've got something else to show you. Let's have a watch.
I've always had lesser included, but I have not seen a verdict slip there where not guilty is not an option for the rest.
Okay, I disagree with you. All
I
right,
don't see the
excuse me. This is funny, Ms. Reed. Excuse me. This is funny, Ms. Reed. All right, we're done.
All rise to the court, please.
Oh my God, my mouth dropped. Did yours? Oh, but I've got more. Let's go back to the Sarah Boone trial, where, ironically, she was smiling quite a bit after jury selection. And I did an update on my community page as to how happy she was, or appeared to be, because she had been smiling from ear to ear. So now, after opening statements and everything, let's listen to what a difference this judge is in the Sarah Boone case and how he treated the defendant.
All right, Ms. Boone, I just got a couple of inquiries of you, ma'am, before we release. Are you satisfied with your attorneys so far throughout this trial?
Definitely.
And are you on board with the strategy that they've employed so far in this trial? Definitely. All right, thank you very much. We'll be in recess till 2 o'clock. Court's off the record.
Was there a difference in the two judges? Were they night and day? I'll let you decide. Did one have a better demeanor? Was one calmer and could explain the law, whereas the other one was fed up and very unprofessional? So, what happens when a judge isn't very professional? Well, there is a case where a judge was very unprofessional, and let's take a watch at what the media had to say.
That her whole vibe was very poor. She displayed poor judicial demeanor and bias, and I could sniff it. You know, I've been around a lot of judges, and you know, this was someone that I think seemed over her head and also seemed very biased and didn't really even try to filter that out or try to keep it in check as much as she should have. So, you know, I applaud her for stepping down, and you know, I think it's a good lesson for other judges out there to be fair.
Yeah, I have to agree.
So I bet you're wondering, what did she do that was so bad? Well, I found a clip from an exclusive interview, and I'll leave you the full video in the description area below.
I guess reprimand or censor an attorney. It was outside the presence of the jury.
But jurors did see some of this heated exchange.
Your Honor?
Yes?
At this time, the defense rests, other than putting in our records.
We're not playing chess. I mean, will you please take the jury back in?
Viewers watched the rest play out between the judge and public defender Melissa McNeil.
I have been practicing in this county for 22 years.
You know what? I don't want to hear it. I don't want to hear
Well,
it.
Judge, you're insulting me on the record in front of my client, and I believe that I should be able to defend
Okay, you
myself.
can do that later. You can make your record later, but you've been insulting me the entire trial. So, blatantly, taking your headphones off, arguing with me, storming out, coming late intentionally if you don't like my rulings. So, quite frankly, this has been long overdue.
If you want to do a little bit of a deeper dive into, you know, how the judge felt, Law and Crime also did an interview with the judge. So that will be good if you want to know a little bit more about that case. I also did a video on the conduct from the attorneys in that case. Let me play you a little bit of the video that I did, and if you're interested, I'll leave a link so that you can watch the rest of it. Let's look at the warning put out by the SRA, the Independent Regulator for Solicitors in the UK, regarding offensive communications, as they were receiving complaints regarding offensive behaviour inside and outside of practice. Essentially, they expect the profession to behave in public places with integrity. When exchanging with others which you perceive or intend to be humorous can be risky. If it is at the expense of others, it may be offensive to a third party. Exchanging with others which you perceive or intend to be humorous can be risky. If it is at the expense of others, it may be offensive to a third party. If you watch the clip I played in full, you will see the Florida defense solicitor is also laughing with her client. Remember, he shot 17 people dead. What does the SRA warning say on being friendly? In a nutshell, being friendly with a client is not a problem, but you must be careful to ensure that your communications remain professional at all times, as you never know when it could be seen by a wider audience. And they have a section on outside the course of business, dealing with social media. It's well worth reading, and think before retweeting an offensive comment unless you are condemning it, as it could be seen as condoning it. Hence, in my opinion, I think this behavior of this Florida solicitor, if she was a solicitor in England, Wales, in my view, this would indeed land her a disciplinary and fine. The Deputy Prime Minister, Lord Chancellor, and Secretary of State for Justice said, The UK can be proud of our world-leading legal services, but it is essential the sector retain its international reputation for the highest standards of probity, meaning a strong moral principle that includes honesty and decency. In England, you can complain about a judge or a magistrate or someone that works in the judicial system that makes decisions. You can do this through the ombudsman. You can complain about their behavior, their conduct, their language, but you cannot complain because they've given you a bad decision that you didn't like when they made a decision about your case. In America, you would have to look up each state's procedure for making a complaint. For example, if there is judicial misconduct, regarding what's happened in the courtroom, if they're rude, abusive, improper treatment of lawyers, witnesses, jurors, court staff, and others. So, showing bias towards anyone in the courtroom based on gender, race, ethnicity, religion, sleeping or drunkenness, or other improper conduct while on the bench. So, so there is ways that you can make sure judges stay in line as well. By leaving a comment, you may help someone else that will read your comment. And of course, I love to read all comments as they are valued, and together we can be more informed. And this information may help you or someone you know. In the meantime, on this channel, you'll find a variety of playlists to suit every curiosity about the justice system. And we provide you with a visual to information and the process. Going through a legal worry is devastating, and the Who Knew and Why Me playlists are designed to help you or someone you know. So please like this video if you like this kind of content. Hit the subscribe button and the notification bell if you want to be notified when I'm going live or upload another video. I'm Karen Cole from Legal Minded Friends. Information is power, meaning if you know something, you can make decisions that are right for you.